Judgment in the matter of Belhaj and another versus Director of Public Prosecutions and another.
Lord Sumption will explain the decision of the court.
This appeal is about closed material procedure. Closed material procedure is an exceptional procedure which may be used in cases where the issues require the deployment of material whose disclosure would be damaging to national security. It allows part or all of a civil action to be heard in private and part or all of the evidence to be withheld from one of the parties. Instead, the material is disclosed to a special advocate whose function is to protect that party's interests as far as he can, but who may not take his instructions on it or otherwise disclose the contents of the material. Closed material procedure is authorized in civil proceedings on stringent conditions laid down in the Justice and Security Act 2013. One of those conditions is that a court must have granted a certificate under Section 6 of that Act that the proceedings are proceedings in which an application for closed material procedure may be made to the court hearing the matter. Such a certificate is available only in civil proceedings. It is not available in what the Act calls proceedings in a criminal cause or matter. Abdel Hakim Belhaj, the first appellant in this case, was a political opponent of the government of Colonel Gaddafi in Libya. He alleges that he and his wife, Fatima Bouchar, were abducted from Bangkok airport by officials of the United States and rendered to the Libyan authorities, by whom they were maltreated and imprisoned. They allege that this was done with the connivance of the British Secret Intelligence Service, and in particular with that of Sir Mark Allen, who they say was a senior official of that service. These allegations were the basis of an action for damages brought by Mr. Belhaj and Ms. Bouchar against the British government and a number of officials. So far as this court is concerned, the allegations against Sir Mark Allen are only allegations. The government, in accordance with long-standing policy, neither confirms nor denies that Sir Mark was involved. The present appeal arises out of separate proceedings which come about in the following way. The Metropolitan Police investigated what happened to Mr. Belhaj and Ms. Bouchar with a view to possible prosecutions. The results of their investigation were supplied to the Crown Prosecution Service. The Crown Prosecution Service concluded that there was insufficient evidence on which to prosecute for any offence said to have been committed in the United Kingdom. That conclusion was reviewed by a different senior official of the Crown Prosecution Service who independently agreed with it. On the advice of the CPS, the Director of Public Prosecutions decided not to prosecute. The identity of the suspect or suspects investigated has not been disclosed either by the CPS or by the DPP. But Mr. Belhaj and Ms. Bouchar began judicial proceedings in which they challenged the DPP's decision to bring no prosecutions on the ground that there was sufficient evidence to warrant prosecuting Sir Mark Allen. In effect, they were seeking a judgment which would oblige the DPP to prosecute him. These judicial review proceedings give rise to a problem. The advice of the CPS and the decision of the DPP was based on a considerable volume of material, much of which has a high level of security classification. The High Court has already given a Section 6 certificate allowing closed material procedure in the parallel action for damages. There is no doubt that those proceedings are civil proceedings. The Secretary of State for Foreign Affairs contends that closed material procedure should be allowed in the judicial review proceedings for the same reasons. The difficulty is that it is not at all clear that these judicial review proceedings are civil proceedings. Mr. Belhaj and Ms. Bouchar say that they are proceedings in a criminal cause or matter, and as such are not eligible for closed material procedure. The Divisional Court held that they were civil proceedings and that accordingly closed material procedure was available. Mr. Belhaj and Ms. Bouchar appealed to this court. After the argument before us, the entire dispute between them and the British government was settled. An announcement was made by the Prime Minister in the House of Commons. but in view of the significance of the issue raised, this court proposes to give its judgment anyway. We hold by a majority of 3-2 that the judicial review proceedings are criminal proceedings and that accordingly closed material procedure is not available in them. The reasons are given in a judgment written by me, with which Lady Hale and Lord Mance agree. Lord Lloyd-Jones gives a dissenting judgment with which Lord Wilson agrees. Are the present proceedings in a criminal cause or matter? They are not proceedings in a criminal cause. That means a trial or an appeal from a trial. But are they proceedings in a criminal matter? That is a wider expression, which essentially refers to the subject matter of the proceedings. Judicial review does not fit comfortably into the traditional division of English legal proceedings into civil or criminal. They are not actions brought to enforce a private right. They are not actions which can result in anyone being convicted or punished for a crime. They are proceedings in which the applicant applies in support of a public interest in having the law enforced against a public authority. Most judicial review proceedings are civil proceedings, but judicial review also has a long-standing role to play in the criminal law. The High Court has a general supervisory jurisdiction over the criminal process which extends to many aspects of criminal proceedings. There are cases in which the decisions of a criminal court may be challenged by judicial review in the High Court. The same applies to police decisions to investigate or charge or administer cautions, or to decisions of prosecutors whether to or not to prosecute, or to the Director of Public Prosecutions whether to consent to a prosecution, or decisions of the Attorney General whether to take over a prosecution or enter a nolle prosequi so as to bring an end to a current trial. These are all criminal matters. In the view of the majority of this court, the question whether judicial review proceedings are civil or criminal depends mainly on their subject matter and on the nature of the decision being challenged. The decision of the DPP not to bring criminal prosecutions was clearly a decision in a criminal matter. In the view of this court, proceedings to review a decision in a criminal matter are themselves a criminal matter. It follows that if the present proceedings had continued instead of being settled, they could not have been conducted under closed material procedure. If the Secretary of State wished to prevent the disclosure of damaging material undermining national security, his proper course would have been to issue a certificate that it was subject to public interest immunity and then to apply to a court for its exclusion. This appeal will accordingly be allowed.